Hi there. It's been a busy time in the Supreme Court of Canada for family law. Very busy time. They've brought down another decision. It came down last week, and it has to do with retroactive child support. Guess what? The Supreme Court of Canada says it can be ordered even after the child is an adult. So, the name of the case is Michelle versus Graydon. And the Supreme Court found that the courts retain jurisdiction over support even after child support is expired and the beneficiary is an adult and independent. So the decision provides some clarity on another decision from 2006 known as DBS versus SRG. I'll refer to it as DBS throughout this, which was asked to interpret Section 15.1 of the Divorce Act, the one that's in force now, not the one that's coming in January 2021, concerning child support, and found that the court was not in a position to grant an order for retroactive support if the child was over the age of majority when the recipient parent made an application for child support. So basically, if your child aged out, the mom, most cases the recipient is mom, cannot bring an application for child support, retroactive child support. In this case, in the Michelle versus Graydon case, which just came down, the court found that under the Family Law Act in BC, and many provinces are the same, that there was nothing preventing from asking the court for a retroactive child support order, even if the child's over the age of majority, which the child was in this case, and the court should not strive to find a reason to disallow those types of applications for support. It was to say that the parent receiving child support was barred from being allowed to bring a retroactive claim after the child was over the age of 18 or independent. It created an incentive for paying parents to avoid meeting their child support obligations. For example, in this case, failing to provide true income and then waiting for child support obligations to expire when the child reaches the age of majority. The justices of the court, Justice Brown was the prime author of the decision, and he had support of the entire court. The entire court allowed this decision. And he found that creating any type of block to a parent bringing these types of child support claims established a, quote, a perverse incentive for parents to avoid meeting their obligations, unquote. Justice Martin agreed with this more technical type of interpretation, but she went even further. She brought in very much social justice themes into her part of the decision. She's saying that it goes much broader. She talked about the feminization of poverty. She delved into social science research and previous decisions of the Supreme Court of Canada about rights of the child and obligations, Canada's obligations under international treaties. In her mind, she would reopen the 2006 DBS decision and would allow originating applications regardless of when they're brought on the basis that child support is a key social issue and children must be presumed to be protected under any intent of written laws. This is quite... Our courts, our justices, are supposed to remain neutral. And this whole social justice theme, feminization of poverty, suggests a leaning in a direction that is not neutral, in my opinion. While it's likely true that of parents who are raising children on low incomes tend to be women, it's just as likely to be the other way around. And I think that the statement that we need to deal with child support as an important social issue because poverty has now been feminized, denigrates both sexes. It's insulting to both sexes. Now, let's talk about this case, Michelle versus Graydon. Let's give you some background. In this case, the mother and the father had lived in common law relationship from 1990 until 1994 in British Columbia. They had a daughter who was born in 1991. Now, note that. This child was born in 1991. This decision is 2020. She's 29 years old. She's not just right out of high school. She's not right out of college. She's not out of university. She's 29 years old. And when the couple separated, when the little girl was small, less than 3, she lived with her mother. Child support was originally dealt with in a provincial court order that was subject to a consent variation order. So the parents consented to change the court order in March 2001, and the father agreed to pay child support of $341 per month. The mother was dependent on income assistance and disability benefits, and under family law legislation in BC, and it's similar in other provinces, a government minister, in this case the government in charge of social services, has the right to receive payments from dad and then transfer that to mom and daughter. It's a way of our governments trying to get parents supporting their children versus the government supporting children. It was later discovered that the father had underreported his income from the time of the first formal court order until the order was terminated. In 2012, the father obtained an order canceling child support on the ground that his daughter had reached the age of majority. She completed a certificate program and was working for a living. In 2015, the mother applied for a retroactive child support order, or increase of child support for the child's benefit back to 2001, and she brought this under Section 152 of the BC's Family Law Act, which describes the circumstances under which a court can change, suspend, or terminate an order respecting child support. Now, it's interesting here, I don't see it mentioned, but what came to my mind is that usually there's a limitation on when you can bring a claim. Quite often, a Limitations Act is 2 years. So unless there's legislation allowing you to bring a claim after that 2-year mark, which in this case, the decision that came down today has removed that 2-year limitation on child support. But at the time, I have to wonder if there might have been a limitations argument here. As far as I know, it wasn't made. So the father contested this application, saying the court had no jurisdiction to make a retroactive order on the basis the child was no longer, quote, a child of the marriage or relationship, according to that 2006 decision, DBS, and because she's an adult. The provincial court, however, found in favor of the mother, and the trial judge ordered the father to pay $23,000 in retroactive child support for 2001 to 2012 when the father's obligations were terminated. This decision, the father appealed. It was overturned on appeal by the BC Supreme Court, and the father, because they agreed with the father that the child must still be a child of the marriage and under the age of majority for mom to bring a retroactive child support claim. The appeal headed to the Supreme Court of Canada. Keep in mind, the Supreme Court of Canada is hearing a decision based on $23,000. There is hundreds of thousands of dollars worth of legal work going into this decision that has now come down. So the appeal before the Supreme Court of Canada raised the issue of whether a court had the authority to grant a retroactive child support order when the retroactive child support is applied under provincial law, and is it prevented by a similar jurisdiction bar or another rule or principle similar to the one in DBS that was found to apply under Section 15.1 of the Divorce Act. The court also raised questions as to whether it was possible to vary an original order under BC's Family Law Act and about varying or increasing the amount of child support pursuant to a court order after the order had expired and the child is no longer the age of majority or dependent on their parents. Justice Brown found that under Section 152 of the Family Law Act in BC, and Alberta law is similar, it authorizes a court to retroactively vary a child support order, irrespective of whether the child's a beneficiary at the time or whether the order has expired. Justice Martin also suggested that this ruling leaves open the question as to whether, if there's no court order in place, an application for retroactive child support can still be brought. This, she points out, is a question for another day. The court didn't deal with it this time, but it certainly opens the door for another litigator to take this up to an appeal court to get that question answered. So, as I had mentioned, this will apply in Alberta, where I practice. And let's face it, if you're hiding your income, you're kind of asking for what's coming at you. The other part of it is the court pointed out that it had the jurisdiction to decide who receives the retroactive child support. It can be portioned out between the mom and the child, or it can all go to the child. So could that be a detriment to moms bringing these claims because there's a potential they may not get the payday? It may all go to the child. Yes and no. We all know that there's a real good possibility that mom could influence the child to cough up some of that money. I could certainly hear a guilt trip of, I did this for you, it cost me so much money, I need to be paid back. I could see it happening. But for some moms, maybe the idea that they're not actually going to receive the check could be a deterrent. My interpretation, my takeaway on all of this is that the court is just doubling down on a current, broken, money-driven family law regime. I see parents using parenting fights that are really about child support fights, whether mom wants primary parenting so that she gets a bigger child support check from dad, or dad wants shared parenting because he wants to pay less child support. Quite often, one parent's about the kids, one parent's about the money. Doesn't matter, male or female. You see this tug of war all the time, and this decision is not helping. I see a bunch of litigation coming that's going to come across just to test dad's income for the children. He has to defend if a claim is brought against him, or he risks getting a decision made against him. And I could, keep in mind, in this decision that's just come down, she's 29 years old. You guys with adult children, with ex-wives who want to take another piece of you, or just give you grief by bringing claims in the court, that is now open. And then, if they win, maintenance enforcement's coming after you for collection. This is definitely going to create litigation. Well, I do agree with them that it's unfair to allow a paying parent to avoid paying enough child support or the proper amount of child support and then be granted essentially immunity because the child is now an independent adult. I do see their point there. There has to be a different solution. The other part of it is that when someone comes to me and wants to pursue a claim, we have to assess, is the juice worth the squeeze? Yeah, I'm sure you've heard that term. But do you want to pay a lawyer $40,000 or $50,000 to get maybe $20,000 back? Sometimes you can get a few legal costs back, but it will never pay the full cost that you're going to pay a lawyer. Yes, I can see this happening. If it's a revenge thing, they won't care. If they get legal aid and they're paying a lot less for a lawyer, I can see it coming. The case that went all the way to the Supreme Court was done by a young lawyer who did it pro bono, free. Didn't cost him anything to pursue. So yeah, I can see it coming, even if they're not going to get very much out of it, even if they win. Family law in Canada is getting more and more complex. There's more punishments, if you want to say. I'm questioning if this is an attempt to scare people into mediation or into doing a settlement rather than pursuing the court process. Because I see it all the time. The justices wanting us to settle. And in an ideal world, we probably could. Marriage, relationships, it's a contract, and a lot of times it's a money thing. But it's emotional, and it's messy, and gets expensive. The other question is if you've got an ex who was on income support, social services, welfare, whatever you want to call it, is the government going to now open files and pursue these old claims to get their money back? That's a possibility. Governments have deep pockets to come after anyone that they think might have been hiding income for children going back, who knows? We know it goes back at least 29 years. So if the goal, as I hear every time, well, it doesn't matter if I'm in docket court or I'm in chambers or special chambers or an oral hearing or a trial, I hear this all the time. The justice is saying they want to reduce conflict, they want families out of the court system, they want something different. And then we get a decision like this, and that this decision is not helping that goal. I think we're going to have a tsunami of litigation over these past few decisions onto an already overloaded family court. It was overloaded before the whole shutdown, and it hasn't improved. In fact, it's just complicated things even more. My take, to be quite frank, is that this is a political case versus a legal case. In Canada, our judges and justices are appointed by the party of the day. So yes, politics are very much involved in our getting on the bench. Depends on whether you've got the right stuff at the time for the government of the period to get appointed to the bench, as is very apparent right now in the United States with the death of RBG and Trump wanting to put another conservative justice on their Supreme Court. But honestly, guys, just be truthful. If the disclosure's there that shows you didn't lie about your income, the application for retroactive falls apart. That being said, sometimes truth is irrelevant in family court. She's going to allege you hid income. It's not true. How do you prove otherwise? And guess which one could be believed more than the other? And I've had files like this where dad is spending tens of thousands of dollars because mom is convinced that he's hiding big bucks and she deserves a piece of it, and he doesn't. I also had a file where I showed mom had received regular income outside of her job for years, before the marriage, during the marriage, after the marriage. She never claimed it on income tax, so it didn't show up on her line 150 that we use to determine child support. And we're in front of a justice who came at me with, oh, those were gifts, counsel. I'm sure mom wouldn't see them as income, and I certainly don't. So in family court, there are at times no law, no rules, no facts. And I would say this contributes to the shortage of family law lawyers because it's a challenge to be a lawyer where you can't always rely on the law, can't always rely on the rules, can't always rely on facts. Sometimes the emotional argument carries the day. So, what's a possible solution, guys? This has come down. It's going to be in law around for a while. First, don't lie about your income. Don't leave that door open to get hit and hammered later for thousands of dollars in legal costs and a settlement thousands of dollars. Second, if you get served with an application asking for retroactive child support for your adult children, I'm going to suggest that I have the dads offer to make payments to the child, so that when I'm standing in front of the justice, I could say, well, okay, dad acknowledges that there might have been some deficiencies in his child support. He's making X number of dollars in payment to the child every month, and has since the application was served. This could show the mom's true intention in court of trying to get a big payday, because then she's going to be forced to explain why she rejected an agreement that would pay monies directly to the child. If she's bringing it to get money for the child, then why is she rejecting this agreement? So, be careful, guys. Children are expensive at the best of times, and be prepared. If you've got that ex in your past who got some money and will likely want more, don't be surprised if you get served with an application to try and get some more out of you. Take care.